Hello friends, I welcome you to our class on rights issues. This is a continuation of our last video जिसमें हमने right to privacy के बारे में बात की थी. अब जो right to privacy की बात की थी हमने पहले, that was about the definition of right to privacy. It was how through the Constituent Assembly debates, the right to privacy gained a legal form, failed to come into the Constitution, and then through different landmark judgments finally ended up being an integral part of our Constitution after the Justice Pottaswamy case, right? Now, in this video, we are specifically going to have a very quick overview of certain Indian legislations that touch upon privacy, because this is important from both prelims as well as mains perspective, and at the same time look at the international perspective and the GDPR, which is important because our own data protection bill has taken certain learnings from the GDPR as well as made it a lot better, right? So let's jump right into our class. Now, in this quick overview of the Indian legislations that talk about right to privacy or have touched upon right to privacy, we first look into the Indian Evidence Act. Evidence is an important part of a trial because it decides if there's going to be a fact that needs to be proven or a conclusion that needs to be drawn through these evidence. One of the type of evidence is witness testimony, जहाँ पे एक witness, if he's been a part of a crime or the witness has some information about the crime, can provide information that lead to conclusion or proving facts of the trial, right? But the Evidence Act itself has an exception. This exception is known as privileged communication. Privileged communication का मतलब यह है कि Evidence Act बोलता है कि there are certain communication that need not be disclosed even if they are required in a trial. ये कौन से communications होते हैं? The Evidence Act has laid down types of communications which can be regarded as privileged communication. ये इस example से आपको पता चल जाएगा exactly ये privileged communication होता क्या है. The first privileged communication we're going to look into is professional privileges. Professional privileges here talks about the privilege that a client has when he is going to an attorney. जिसका मतलब ये है कि अगर मैं आज एक advocate के पास जा रहा हूँ, एक legal practitioner के पास जा रहा हूँ, अपने केस को लेके, जहाँ पे मैं उनको अपनी केस की हर डिटेल बता रहा हूँ, I shouldn't be in a position where मुझे इस बात का डर है कि कहीं मेरे एडवोकेट ने जाके मेरा ये इन्फॉर्मेशन कहीं और रिवील कर दिया तो. So that this doesn't happen, so that the client himself is not under pressure that the advocate might reveal his data or reveal his own information or jeopardize his own case, the court has regarded and the Evidence Act has regarded this communication as a privileged communication, right? क्योंकि मुझे भी तो भरोसा चाहिए for my own free and fair trial, right? Now, similar thing happens with affairs of the state. It says that a person cannot present evidence from an undisclosed piece of information that relates to state affairs. मतलब जो चीज़ स्टेट की पब्लिक आई में नहीं है, हम उस चीज़ को एज एन एविडेंस प्रेजेंट नहीं कर सकते, क्योंकि अगर ये करना होता फिर क्या होता, इसी के नाम पे, ट्रायल के नाम पे बहुत सारी इन्फॉर्मेशन लीक हो जाती, बहुत सारी स्टेट की इन्फॉर्मेशन लीक हो जाती, बी इट रिलेटेड टू डिफेंस, बी इट रिलेटेड टू सिक्योरिटी और फाइनेंस, राइट? Same thing happens with official communication, where a public officer cannot be compelled to reveal certain data that might jeopardize public interest. Same thing happens with secret informants. This might make it even easier to understand that a person, if he gets a tip about, let's say there's going to be a riot or there's going to be certain financial illegal work that is going to take place, tomorrow if I conduct as a police officer or as a revenue officer, if I conduct a raid, I am not liable to reveal who my secret informant was. The court says and the Evidence Act says that I'm not liable to reveal who my source is, just to prevent these sources being targeted, just to make sure that public safety and public interest of our country is maintained, right? And then the final privileged communication talks about communication during marriage. It says that a communication that happens between a husband and a wife during or even after their marriage, during their marriage, or if this communication is to be revealed after their marriage, it has to be from both sides consent. बिना consent के, चाहे ये information confidential हो या ना हो, marriage के time पे जो बात करी गई थी, that is also regarded as a privileged communication. इसका कारण क्या है? इन चीज़ों को प्रिविलेज कम्युनिकेशन बनाने का एक ही कारण है, वो ये है कि टू मेंटेन हार्मनी इन द कम्युनिटी such things are important, because if these things are not done, if these information are not kept away from the trial purview, then इसके थ्रू बहुत सारे information leak हो सकती है, बहुत सारे लोगों के ऊपर it might cause a lot of unfaithfulness in the community, be it the attorney-client relationship or be it the informant and police officer relationship, and at the end of the day it might jeopardize marriage. It might jeopardize marriage where a husband and a wife will always have to keep each other in check कि कहीं मेरी information ये बाहर ना कर दे, right? So that is the reason why, because the court and the Evidence Act in this sense was a very wholesome act. It looked into these privileges, it looked into these privacies that are required in terms of communication, and hence laid down what is known as privileged communication. Moving forward, we have the Indian Telegraph Act. Very quickly looking into the Indian Telegraph Act, it is also known as the Phone Tapping Act, because this act, section 5, subclause 2, talks about how the government can intercept telephonic conversation, right, or phone tapping. When this act, till 1996, till this People's Union for Civil Liberties versus Union of India case 1996, right before this, the way how the phone tapping was happening was very vague, because even though the act says that it can be only done during public emergency and interest of public safety, the government would cite this public emergency and interest of public safety in most of the cases just to spy on political opponents. ये चीज बहुत बार हुई थी. इनफैक्ट इसी की वजह से ये केस आया था. This came through a PIL that one of the politicians had went to the Supreme Court and said, this is breach of my privacy. My telephonic conversations are being recorded, are being surveilled, and are being watched by people that I don't want. And even though I myself am not jeopardizing any public safety or public interest of public safety, my phone is being tapped. So to this, the Supreme Court came into rescue and said, it in fact laid down the rule 419A, which says that, number one, अगर phone tapping करनी है तो इसका जो authority आएगा वो होम सेक्रेटरी से आएगा, इफ इट इन केस ऑफ गवर्नमेंट ऑफ इंडिया, और स्टेट के होम सेक्रेटरी से आएगा इन केस ऑफ द स्टेट. ये जो ऑर्डर आएगा, राइट, फॉर फोन टैपिंग. सो यू क्रिएट वन layer of prevention so that it cannot be used randomly. Second prevention that was added to this was that once this authority has been given for phone tapping, a review committee should receive in written why this was done within 7 days of such an act, right? So that these two rules under the 419A make sure that phone tapping cannot be done incessantly. It cannot be done all the time, and it cannot be done without any rhyme or reason. And then the court also propounded on public emergency and interest of public safety by saying that this has to be one of the key reasons. A public safety or public interest तो India Telegraph Act ने define किया नहीं था. So the court went ahead and interpreted it in a way that said that anything that threatens the integrity and sovereignty of India, that threatens the state, that threatens public order, that threatens the foreign friendly relations with foreign states, and might go ahead and incite criminal acts or violence, these can be considered public emergency and interest of public safety. Then and only then can someone's phone be tapped, right? So the Indian Telegraph Act already put forward a check and balance system, which was again enhanced in 1996 by the Supreme Court. So Indian Telegraph Act, the way this is about interception of conversations or calls, the Information Technology Act of 2000 and the IT rules of 2009 is about interception of digital information, of digital data, right? So the Information Technology Act says, and see, the Information Technology Act is a broad act that deals with different digital avenues. But Section 69A is what is important for us. The most important thing here is Section 69A. ये आप लोगों ने देखा होगा जब फार्मर प्रोटेस्ट चल रहा था और उस टाइम पे जब ट्विटर अकाउंट्स ब्लॉक किए जा रहे थे बहुत लोगों के. इनफैक्ट दिस इज द सेम सेक्शन दैट वाज इवोक्ड व्हेन TikTok was banned and other 52 or 59 Chinese apps were banned, right? It was this section 69A that was evoked. What does the Section 69A say? It says that if a website threatens India's defense, sovereignty, integrity, friendly relations with foreign countries, same things that are written in the Indian Telegraph Act, if it is evoking these, the government can go ahead and ban it following due process of law, right? Then it also has a section 72 and 72A, which again talks about certain breach of confidentiality and breach of lawful contract. दोनों का मोटा माटी मीनिंग ये है कि if let's say you and I have entered a contract, and by entering this contract, this could be any business arrangement, it could be any conversation, it could be any financial or any legal sort of arrangement between you and me. It's a lawful contract. You and I have entered it, and by entering this, you have obtained certain personal information from me, certain personal information, data, or communication. And now at this point, if you go ahead and disclose this information, then you are in a breach of my privacy. You're a breach of my confidentiality and privacy, and that is punishable under law, under section 72 and 72A, right? So these three acts became the backbone of privacy in India. They became the backbone of how privacy was seen in India through these three acts, right? And then we have certain sections in the Indian Penal Code as well as the Criminal Procedure Code that have touched upon privacy. The first one in the Indian Penal Code, the main one, which is defamation. Section 499 to 502 talks about defamation. Defamation means bringing harm to one's name, bringing harm to one's personality by false information, right? Now, defamation, the Supreme Court here recognized that bringing harm to someone's personality, and personality being a part of self, is again private. And this harm that is brought through defamation is again touching upon the right to privacy of a person. You cannot harm someone's someone's own personality. This is again amplified when it comes to modesty of a woman. It says that if a modesty of a woman is challenged by, if it's harmed by sound or gestures or anything, again, it leads to defamation, which is a serious punishable offense. So the Indian Penal Code has also through this section on defamation has spoken about how your own personality to you is private, and how a harm to this is going to be a punishable offense. Similarly, the Criminal Procedure Code recognizes in section 51(2) that when searching a woman, it should be done by a female officer, making sure all the decency is maintained, right? Similar thing is under 53(2), where the medical examination of a woman is to be done by a practicing female medical practitioner, right? Same things, where the Criminal Procedure Code again recognizes that a woman and her body is private, and this can only be maintained if the search and evidence is done under a female officer and under a female medical practitioner, right? Then comes section 164, which is about voluntary confessions. अब 164 इसके ज़्यादा डिटेल में जाने की ज़रूरत नहीं है. We only need to know the broad aspect. Remember, prelims or mains, whichever exam that you're concentrating on, it will always look at your own understanding. You don't have to mug up the sections. So section 164 talks about voluntary confession. Voluntary confession says that especially in cases of sexual assault, a victim can go to a magistrate and get her statement recorded, which will be taken as an evidence, right? And this recorded statement has to be private and cannot be disclosed unless the whole case is over. A good example here would be जब स्वामी चिन्मयानंद का केस चल रहा था, and the sexual assault victim had approached the magistrate and registered her confession under 164, section 164. The people from Chinmayanand's side started pressuring the magistrate to give us the official statement so we can work on it. But by doing so, the magistrate refused, right? But by doing so, he would have disclosed what was said, who said it, how they said it, and everything, and that would have put a lot of pressure on the victim itself. And that is the reason why the Criminal Procedure Code recognizes privacy in section 164. And then we finally come to family laws. Now, in family laws, most of the family laws, be it the Hindu Marriage Act or the Indian Divorce Act, it gives a provision of in-camera proceedings. थोड़ा सा साइड में लेके एक बार इन कैमरा प्रोसीडिंग्स के बारे में बात कर लेते हैं. See, the court has two types of proceedings. We know the court is an open court. The Indian court is an open court. What does open court mean? Open court means that every single case can be viewed by the public. Here, public can be the media or the normal public. And then there are in-camera proceedings. In-camera proceedings are those proceedings that are to be held in confidentiality through video conferencing. ये क्यों किया जाता है? ये exceptional cases में किया जाता है to prevent the identity of the victim from being leaked, to prevent any extra pressure, be it financial, monetary, or political, on the victim, to provide security to the victim itself. For example, let's say in a high-profile case where a person has accused a politician, right? This person can ask for an in-camera proceedings because this person knows that अगर मैं आज कोर्ट में गया तो politician के कुछ गुंडे आएंगे, मुझे मार के चले जाएंगे. So to prevent such cases, in-camera proceedings is done. Remember, in-camera proceedings does not mean कि कैमरा लगे हुए हैं, सब लोग देख रहे हैं. In-camera proceedings is proceedings through video conferencing, where the person related to the case are not required to come physically to the court. This is very different from video conferencing जो Zoom call के through होता था. ठीक है? Now, family laws have this provision of in-camera proceedings because the court recognizes that family or the relationship between a husband and a wife is a very intimate one. So what happens between the family should stay in the family if if both party agree that this needs to be solved between us, and this should stay in the family. So through all these acts, we see that the Indian court, the Indian legislations as well as the Indian judiciary has recognized right to privacy in certain legislations. Right? Now let's quickly move on to the international side of this. Now, in discussing the international side of this, one of the most important things that we need to look at is what does the main human rights body, the Universal Declaration of Human Rights, talk about when it comes to privacy. Now, the Article 12 of the Universal Declaration of Human Rights very explicitly mentions that no one shall be subjected to arbitrary interference with his privacy, his family, home, or correspondence, nor to attacks upon his honor and reputation. So very clearly, in very short, the Universal Declaration of Human Rights says that जो right to privacy है, it extends not only to that person but also to the person's family. It extends towards the home. Remember, we spoke about how a person's home is an invaluable asylum, right? वो एक पवित्र जगह है, वो एक sacred जगह है. एक person का घर वो एक sacred जगह है जिसके अंदर breach करना is breach of privacy. And it also talks about correspondence. What we spoke about in secrecy of correspondence, phone tapping, right? And it says finally his honor and reputation. What we saw in defamation, right? A person's own personality, a person's own persona is also part of his own privacy. So the Universal Declaration of Human Rights clearly states these things out. And then it goes ahead and says that everyone has the right to the protection of law against such interference or attack. That not only these are to be recognized, but these are to be protected by law. And they are to be protected from all interference and attacks, be it from the state or non-state actors. Right? Now, these are the same words that get echoed in different provisions. Be it the ICCPR, which again verbatim repeats the same thing that the Universal Declaration of Human Rights does in their Article 17 for privacy. Now, same thing gets repeated for Convention on Rights of Child. Their Article 16 just substitutes no child shall in terms of no one shall, right? And then the same thing repeats verbatim. Same thing happens with all migrant workers and members of their family, उसका जो convention था. And यही चीज़ regional instruments में repeat की गई है about privacy, about home, about correspondence. But the problem here that occurs is all these laws came during a period where the digital life hadn't developed. Internet तब नहीं था, phones तब नहीं थे, cameras तब नहीं थे. उस टाइम पे ये laws आए थे. तो then the privacy stayed limited to one's home, one's correspondence, and one's family, and honor and reputation. But now we have a new dimension to this, which is the digital life. We have one digital life. We have our own data that is being transmitted throughout the internet. And because of this, there was a big need felt to somehow not only prevent privacy of one person, but also prevent one's own personal data. So we went from privacy to personal data. And the reason why this was important was because of these three things: globalization, interoperability, and the digital life. Now, what is globalization? We very well know what globalization is. The physical borders disappeared, right? Globalization means that the geographical borders disappear. And that's what happens with data, and that's what happens with our own private information. अगर आज मैं एक अमेरिकन वेबसाइट में जा रहा हूँ और अमेरिकन वेबसाइट को ब्राउज कर रहा हूँ, that website is going to throw some cookies at me. Cookies are nothing but data trackers on a website. These cookies will track what are the places I'm clicking, what are the other websites I'm visiting, what I'm doing, and then ये जो information है जो इस cookie ने track करके लिया मेरे से इस अमेरिकन वेबसाइट ने, ये जाके डिफरेंट और देशों के वेबसाइट में ये बांट रहा है, चाहे वो चाइना हो, चाहे वो कंबोडिया हो, चाहे लाओस हो, ठीक है? And this, because of this globalization, suddenly my information sitting here in Delhi now gets disseminated everywhere around the world. That's why, that was the first reason why we needed a bigger or a much more advanced personal data protection plan. Then comes interoperability. आज अगर मैं अपने फ़ोन के थ्रू सर्फ कर रहा हूँ, किसी इंटरनेट कैफ़े में जाके सर्फ कर रहा हूँ, या किसी वीडियो को वॉच कर रहा हूँ, चाहे वो फ़ोन हो, लैपटॉप हो, कंप्यूटर हो, किसी में भी, because how internet works, because it works on every single device and it collects data on me based on different tickers. Be it me watching a video, it will tell them about my preference. Be me shopping online, it will tell them about my preference. Be it me eating certain kind of foods or watching certain kind of shows, again will tell certain kind of preference about me. And because of all these interoperabilities, it becomes even more necessary. क्योंकि अब तो मेरा प्रोफाइल बनाना बहुत easy हो गया है digitally. Because I'm visiting different websites and I'm giving different information out. And because this information is being shared cross-platform, it's being shared across websites, making my profile becomes very easy. Making my own digital profile becomes very easy. And then again, we come to digital life, which again talks about how the phone has become a part of me. Phone has become a part of my personality. आप देखेंगे हर पर्सन का फोन, चाहे वो आईफोन हो, चाहे वो कोई एंड्रॉयड फोन हो, सबका फोन looks different. You won't find two phones when you open them looking the same. Why? Because you have personalized the phone. The phone has taken on your persona. And that persona is being transmitted all through all platforms, right? Now, because of this globalization, interoperability, and digital life, what has happened is your own digital data and your own data is now being used by different companies. Now, ये जब हमारे यूनिवर्सल डिक्लेरेशन ऑफ ह्यूमन राइट्स था या ICCPR था, ये जब आए तब ये वाला डायमेंशन था ही नहीं इनके पास. Then privacy was limited to the physical circle. Now it has expanded to the digital circle. And to tackle with this, that's why European Union came up with their GDPR, which is General Data Protection Regulation. Up GDPR, it came out in 2018 and now it's 2022, so it's been 4 years. So we'll look into how it has been since the last 4 years. But essentially, GDPR, what it did was, for the first time, it tried to regularize the data that is being used by different websites. It laid down 7 principles. It laid down 7 principles which ensured that the data that is being collected is collected through consent of the person, right? So let's look at the 7 principles in a very brief way. Jaldi se dekh lenge ek baar. So the first principle was lawfulness, fairness, and transparency. It says, जो भी data collect हो रहा है, there should be a legal precedent behind that. There should be a legal provision under which the data is being collected. It should be collected through fair means. जो चीज़ बोल के collect किया जा रहा है वही चीज़ के हिसाब से मैं collect करवा रहा हूँ. And it should be transparent, which means that if you're saying that my data is going to be used for a particular thing, then I get to know exactly what thing it is being used for. अगर मुझे बोला जा रहा है कि मेरा सॉफ्टवेयर मेरे से मेरा लोकेशन प्रेफरेंस लिया जा रहा है टू सेल मी अ सॉफ्टवेयर, then tomorrow you cannot use it to sell me life insurance policies, right? So the very first principle talks about lawfulness, fairness, and transparency. And इसी में it covers one big thing, which is consent. If I give consent for you to collect my data, then you should do it lawfully, fairly, and by being transparent. The second is purpose of limitation. Very easy to understand. Purpose of limitation talks about one clear thing. जितना डेटा चाहिए, जिस काम के लिए चाहिए, डेटा उसी काम के लिए लिया जाएगा. So if the purpose of if you're collecting data to give me, let's say, a medical form, and you need my name for it, then I am supposed to get the medical form just by giving you my name. You cannot demand more. And उसी में ties in my data minimization that talks about जितना डेटा चाहिए उतना ही लिया जाएगा. जितना डेटा चाहिए उतना ही लिया जाएगा, उससे ज़्यादा नहीं लिया जाएगा. So purpose of limitations talks about how the data you're collected is limited to only the purpose that you've taken it for, and minimization talks about that there won't be any spillover. There won't be any spillover. If take as minimum data as possible for you to achieve the purpose. The purpose should be achieved with as minimum data as possible, right? Then comes accuracy, which says that the data that you have collected should be accurate. Now, if you've collected 5 years ago that my age was 18 years old, if you've collected 5 years ago that I had certain medical condition, and today if I don't have that, today my age has increased, then the website which is collecting this information should keep it accurate. Should make sure that the data that they had collected is now accurate and up to date. Then it talks about storage limitation. Very simply, storage limitation says that जितने टाइम के लिए डेटा चाहिए उतने टाइम के लिए ही डेटा लिया जाएगा, उसके बाद ये डेटा नहीं यूज़ किया जाएगा. अब इसका मतलब ये नहीं कि एक कंपनी बोल देगी अरे ये डेटा तो मैं इनफाइनाइट टाइम के लिए लेना चाहता हूँ बिकॉज आई डोंट नो व्हेन आई एम गोइंग टू यूज़ द डेटा. यू कांट डू दैट एनीमोर. यू हैव टू give a go ahead on how long you need the data for. You should have an expiry date on the data, and this ties in with our right to be forgotten, which means that tomorrow if I want them to delete my data, if I don't want them to have my data anymore, then that should itself be a storage limitation, and they should be compelled to delete my data. Number 6 talks about security. Now, a lot of people believe that GDPR is about security, that GDPR helps securing the data because it puts certain mandates. Company के ऊपर वो कुछ regulations लगाते हैं जिसके through the company needs to make sure that all the data is secured. It kept securely, it's transmitted securely. ये जो हम WhatsApp में देखते हैं end-to-end encryption जो होता है, it's part of security, right? Encryption is part of security. The servers where the data is kept is part of security. But GDPR is not about just security. As you can see, it's about how collection of the information happens, how the processing of the information happens, how long the information can be, user information can stay with the website. And finally, it talks about accountability. Accountability is a culmination of all this. अगर ये पहले की 6 principles हैं और accountability नहीं है, then it won't matter. It's the same as Article 32 of the Constitution. If the Supreme Court is not going to prevent the fundamental rights from being violated, then there's no point of having fundamental rights. Same thing happens with accountability. And इसी accountability के अंदर the GDPR says that if there's a data breach by any chance, then the consumer, the whose personal data is being breached should be identified within 72 hours. ये पहले नहीं था. It came after GDPR came into being. इससे पहले if the data leaked, you wouldn't even get to know. And all of this came in the wake of things like Cambridge Analytica, things like big leaks and big papers being scammed from one country to another, right? And that's why GDPR became so important. So in the last 4 years of GDPR, from 2018 to now 2022, what has happened? Like if we take a stock of how the GDPR performed, we would see that data breach warnings have increased 6 times since GDPR came into play. So now people are being regularly informed if their data is breached, and इसकी वजह से क्या हो रहा है? You are able to quickly secure your own information, quickly change certain passwords, quickly change certain usernames so that your data cannot be transmitted or used by other people immediately, right? Then it gave you the power to view, download, and delete your own content, which wasn't there before. Today, you get to, if a company is collecting your data, you get to see what data is being collected. You get to download the data they collected, and you get to ask them to delete the information they had collected. The onus, the consent, the onus is given on the consumer itself. And finally, it has given us more information about the data that is collected. It has made mandatory to the digital companies to share what the data is being used for. And because, see, in right to privacy, the reason we are talking about data, personal data, is because this is what right to privacy is now. Right to privacy needs to be seen from the digital age. Tomorrow, if UPSC asks you a question in essay, in your GS papers, in your mains, or even in prelims, the conversation is not just going to be about which law, which section. It's about the interpretation of privacy, and in today's age, interpretation of privacy is coming from the digital age. Now, if you look at just the comparison between the GDPR and from 2018 versus how it's performed now, the biggest breach that we see is about consent. Even though the whole GDPR was regarding consent, it also in their Article 6, under lawfulness of collection of data, they have spoken, उसमें उन्होंने एक point तो ये बोला है कि you need the consent for collection of data, but it has also given this line which says a company can collect your data for purpose of legitimate interest, and this has become a grey area. This has become a grey area in GDPR, where a lot of companies have come to abuse this purpose of legitimate interest and continues to collect your information even without your consent. So that sort of gives us an overview of what GDPR is, right? And in the next video, we'll conclude the whole right to privacy by quickly looking at the data protection bill that is coming in India, having a small comparison with the GDPR, and then concluding by looking at any new laws that are coming in, be it the DNA bill or the criminal procedure identification bill. I hope you've enjoyed this class. Make sure your preparation goes well. Keep at it, and I wish you all the best.